Hello, I'm Evan Way, an attorney here at Crow and Dunlevy and a member of our Labor and Employment Practice Group, here to provide the weekly employer wrap-up. So this week and past week have had a lot of changes with the Paycheck Protection Program, or the PPP. On Friday of last week, President Trump signed into law the Paycheck Protection Program Flexibility Act, or our newest acronym, the PPPFA. What this does is it modifies the current PPP to allow greater flexibility for employers on how they spend the money. Some of the key highlights and the takeaways from this is underneath the old rules promulgated by the Treasury Department, you had to spend at least 75% of the loan proceeds on eligible payroll costs to be entitled to full forgiveness. This was the 75-25 rule that was in effect. With the PPPFA, it is codified that this is now reduced to 60% of the loan proceeds can be spent on eligible payroll costs to receive full forgiveness. So now we went from the 75-25 rule to the new 60-40 rule for full forgiveness. In a joint statement that was issued by the Treasury Department and the SBA on Monday of this week, it made it clear that you could still apply for partial forgiveness even if you didn't meet that 60% threshold, but your forgiveness will be reduced by that 60% threshold. So great news as far as having greater flexibility to spend funds on non-payroll costs. One of the biggest changes was the 8-week covered period where you had to expend these funds from receiving them to using them and then applying for forgiveness afterwards has been extended from that 8 weeks when you received it to 24 weeks or December 31st, which is ever earlier. There's also a change of the safe harbor provision for bringing your workforce back to its full-time equivalent levels of the February 15th, 2020 levels. The old safe harbor was you had to reach that FTE by June 30th. Now it's been extended to you need to reach that FTE number by December 31st, which is great news because there was many businesses that still were not operational, could not return their workforce, and were not going to be able to do so by that June 30th deadline. So if you were currently underneath the old 8 weeks and everything was going great and you want to stay under that, the PPPFA also makes clear that you can follow the old rules and old guidance and adhere to the 8-week covered period instead of extending automatically to the 24-week covered period. So that allows employers a little bit more flexibility on how to spend money, from the 75-25 rule to the new 60-40 rule, and also allows for partial forgiveness if you can't satisfy full forgiveness for the 60-40 rule. It extends your safe harbor provision to restore your FTE level to your February 15, 2020 levels from June 30th to December 31st of this year. And there's also some other changes that go into effect. Before, under the promulgated rules, it said that if you made a good faith offer and documented to a previous employee you had on February 15th, and they refused to come back to work for you, that would not count against your FTE levels. The new guidance makes clear that if you also are unable to hire them back or find qualified workers to replace them, that will also not count against your FTE levels. And another carve out was if due to restrictions from the CDC that were in place that would not allow you to rehire these workers, that will not count against your FTE levels as well. Now, guidance on how this is going to be implemented and exactly what it means from the text of the PPPFA that was signed into law last Friday, that remains to be seen. But the Treasury Department and the SBA's joint statement made clear that new interim rules would come out and new FAQs would be published, updating this guidance and what employers needed to do to document why these employers were not brought back. The good news is that if you are using the 24-week period, we should have plenty of guidance by then to really walk you through what needs to be done and what documentation is going to be required. If you have not applied for a PPP loan yet and you intend to do so, your deadline is going to be June 30th. There is approximately $131 billion left, so they anticipate that more businesses will be able to get out there and use the funds. They're currently working to reduce some of the restrictions on the original PPP and the SBA's guidance saying that if you had a criminal conviction within the last 5 years, they're going to reduce it from 5 years to 3 years to hopefully encourage more businesses to apply for this money. The good news is businesses applying for it now, the maturity date for the loan is going to be extended from its current 2-year period to the 5-year period. If you already have a loan, you're most likely locked into that 2-year period, but you can negotiate and work with your lender to extend it to the 5-year period if that's something that you want to do. One of the other big changes from the PPPFA is the CARES Act made clear that if you applied for and received the PPP loan, you could not then take the deferment provision underneath the CARES Act to defer employer payroll taxes. The PPPFA makes clear that you can also now take the PPP loans at any time and still defer your employer payroll taxes. So another great thing for employers right there. This is just kind of a broad overview of everything that changed with the PPP. As always, if you have questions about the PPP or the changes implemented through the PPPFA, we'd be more than happy to assist and continue to publish updated guidance at our website at www.crowdunlovey.com on our COVID-19 Resource Center. Thank you and have a great day.